Shima, we are live. You need to start.
All right, ladies and gentlemen, we are live and good afternoon. Welcome to BW Legal World's Saturday Solution segment where we speak with experts on hot legal topics and latest legal developments. And speaking of which, we are discussing a very interesting Supreme Court ruling from the desk of Justice Nariman, regarded as the lion who guarded the judicial institution. And he retired from office on Thursday, delivered the ruling on August 6th that came in the wake of a dispute between Amazon and Future Group, which has cleared up some of the clouds on relatively new concept of emergency arbitrations and awards in India. Now, we'd like to know from our experts the position of law, pre-judgment, in a way that the judgment sets the right precedent to showcase India as a pro-arbitration seat. Now, to make this happen, we are joined by Ms. Shruti Sabharwal, partner Shadu Ramachan Mangada, Ms. Kritika Krishnamurthy, partner AK and Partners, Mr. Suvigya Avasti, associate partner PSL Advocates and Solicitors, Mr. Alok Jain, associate partner Economic Laws Practice. Thank you, experts, for joining us today. And I'm Ashrama Ori, managing editor of PW Legal World. I'll be your host for the day. I'll jump right to the questions without further ado. And my first question, opening the floor, is to Ms. Shruti Sabharwal. Shruti, what are some of the relevant sections that we'd like our audience should know about before we delve any further into the case? And also, if you could shine some light on, this is a new concept of emergency arbitration to most of us. Now, where were we before this ruling, and what has come our way now? And how has this judgment plugged some of the lacunas in the legislation? Over to you.
Thanks so much, Ashima. Thanks, everyone. Thanks for having me here today. Certainly to just start with the judgment, it's a very welcome judgment. Supreme Court is really a gift that keeps on giving in terms of arbitration, at least. This was Justice Nariman's parting gift to us as arbitration practitioners, and we're very grateful for it. To answer your first question, which was about the relevant provisions which one needs to look at to understand the judgment, to simplify it, I would say that what Justice Nariman has essentially done is focused first on concepts from the Act relating to party autonomy. So for that, he has looked at the definition of arbitration under the Act under Section 2, read with Section 2.6 and 2.8, which basically allows parties to have an issue determined by an institution or have their agreements refer to institutional rules. So his starting thrust is really on party autonomy and recognition of institutional arbitrations in India, and coming really to the meat of what he discusses in terms of enforceability of an emergency award in India. The relevant provisions one should look at are Section 17. Section 17, as we all know, provides that a party may, during arbitration proceedings, apply to the arbitral tribunal for certain interim reliefs which are listed in the section. So interestingly, what Justice Nariman has done is look at what is there along with what is not there to basically come to his decision to say that emergency awards are enforceable. To this end, he specifically looks at the fact that the term arbitral tribunal is defined to mean a sole or a panel of arbitrators. But reading that with the sort of opening of Section 2, the definition section, which says, unless the context otherwise requires, he has read it to basically say that Section 17 is broad enough to include institutional arbitration by virtue of party autonomy. And accordingly, if you've chosen rules which provide for emergency awards, then those awards will also come within the ambit of 17.1. So that is essentially, the relevant provisions. Separately, of course, he's also dealt with the issue of appealability of an order enforcing an emergency award under 17.2. So the relevant provision for that is 17.2, which provides that an interim order by the arbitral tribunal is enforceable as though it is the order of a court. Read with Section 37, which is a very interesting discussion we can certainly go on to during the course of the talk today, which provides for what exactly is appealable under the Arbitration Act or not. So these would be broadly the sections. I mean, there's a lot of reference to Section 9 as well, but I mean, we'll discuss that during the course of
Yeah.
today.
Thank you. Thank you so much, Shruti. I would like to, go around the table once and take everyone's comments just to get the discussion flowing from there. So I'll move to Kritika. Kritika, your opening comments and taking from where Shruti has left us.
Thanks, Ashima, and thanks, BW Legal World, for inviting me for this very, very interesting session today. What I really feel is that, in a way, because the names in this dispute are big, and because we haven't had any decision on emergency arbitrators yet, this has really brought to front an issue we really face while protecting shareholder rights. Especially in the COVID situation right now, and otherwise as well. We as practitioners really struggle when shareholders come to us with a dispute and they need absolutely urgent interim relief. They want something that they can protect their business interests while at the same time not allow the other party to do something that can hurt their shareholding or the company. And we really don't have anything presently that can give this. I mean, unless you have big guns, you have to also look at the ecosystem which has MSME startups and so many other people. And we really don't have any statutory provision that really protects them really on the ground and gives them absolutely urgent interim relief. From that perspective, I think if you bring in, you say that the emergency arbitrators are a venue available and that you can have them through institutional rules, I think this is going to be path-breaking for shareholder disputes in India.
Thanks, Kritika. Quite well noted that, it has been a sigh of relief probably for the MSME sector and not the big guns, so to say. So moving to Alok, Ms. Jain, would you please tell us, what are your thoughts on the ruling?
Yeah, thanks, Ashima. So I do agree. I mean, it is a parting gift, as Shruti said, from Justice Nariman. And I think a better gift is the fact that now he's potentially a nominee arbitrator. So I think that would be possibly the best outcome in all of this. But yes, coming to the topic, I think in terms of an emergency award, what this decision has actually done is it has, in essence, done what the legislature wanted to do way back in 2015. And they have, in fact, if I may say so, legislated on behalf of the legislature and also brought in the concept of emergency awards in India when specifically it's not been provided for. But I think when we come to understanding the impact of this decision, and as Kritika rightly said, it is very important from a shareholder's perspective, but it applies across the board in construction disputes because emergency relief, as the very name suggests, is something that you require on an ASAP basis. It's not something that you would even want to file a petition before the court under Section 9 or attempt to go there. You have an avenue right in front of you. And in fact, in our experience, emergency arbitrators are appointed overnight. And that is something which is key over here in terms of what this decision brings to the Indian arbitration scenario.
Thank you so much, Alok. Suzuki, over to you. Like Alok mentioned, an overnight emergency arbitrator can be appointed. How has this, how does this actually change things? And what are your thoughts on the ruling?
Thank you, Ashima. Taking over from where my colleagues left, it is certainly a very welcome step. In fact, I'd say that's the latest jewel in the crown, that is India's pro-arbitration regime. Especially the judiciary has taken strides in this way, and they've delivered many significant judgments. However, I think this being a treatise on contextual and purposive interpretation by Justice Nariman, where he actually interpreted the loopholes in the statute to signify what was not expressly included by the legislature after the 2015 amendment. one has to ask this question and wonder why the legislature did not expressly accept the recommendations of the 246th Law Commission, and also take into consideration the high-level committee report, which was passed subsequent to the amendments in 2015, which said that looking into the judgment of the Delhi High Court in Raffles design, which specifically said that emergency arbitration awards in foreign seated arbitrations are not specifically enforceable in India. This judgment has certainly set the court straight for domestic seated arbitrations, as was the case here, as it was seated in New Delhi. It's definitely a welcome step, but it also raises some very pertinent questions which I'd like to discuss in the course of this webinar. Thank you.
Thank you, Sivakan. Thank you, panelists, for breaking the ice on this. And now I'll go to Shruti again with my pointed questions. Shruti, like you mentioned, and as has been the case, I'll try to pick up one line from the judgment itself. In fact, it says emergency arbitrator who is not an arbitral tribunal, but a person who only decides at best an interim dispute between the parties which never culminates in a final award. Now, this has been the mindset before the judgment. Now, can you, elaborate on this for us and take us through what has been the position, how it has changed, what has India's position of law and on emergency arbitration been, was emergency arbitrators award outside the ken of Arbitration Act? Over to you.
Thanks, Ashima. I mean, it is a very interesting question because essentially our law was completely silent on the aspect of or the concept of an emergency arbitrator. Does it mean that, Indian courts were saying that, oh no, you've come to me with an emergency arbitrator award, I'm not going to touch it? Absolutely not. The practice as it stood by virtue of the fact that there was nothing in the act was that, and it's normally in foreign seated arbitrations, we would get an emergency award, we would have to come to the courts in India under a Section 9, ask the courts to essentially pass a mirror order or a similar order, as passed by the emergency arbitrator. And only then would we get to really enforce an order of an emergency arbitrator. So the problem obviously for parties is that you're choosing arbitration to sort of stay as far as you can from the rigmaroles of the judicial system, especially in terms of, the procedure, the timelines it takes, the cost, everything. So what was happening is that parties had an award, they wanted to enforce this award, but then it meant they had to spend a whole bunch of money, time, and effort to essentially get something with teeth. So, I mean, courts have done it. I mean, I think one of the first judgments was Bombay High Court in Avitel Solutions, where they passed the Section 9 order. This was done subsequently, in Raffles, for instance, by the Delhi High Court. So courts have been following the system. And interestingly, as Subhagya said, the difference in this judgment versus those is that this is an India-seated arbitration. And those judgments are all foreign-seated arbitrations. So there is a slight distinction as to, what this judgment really provides for. In terms of, like we said, I think Alok and Savigya both mentioned the Law Commission report had, the 246 Law Commission report, I think, had suggested, introducing the concept of emergency arbitrators. I think Justice Sri Krishna Committee in 2017 had also once again, pushed for this. Certainly, it didn't find a place in the 2015 Act. It didn't find place in the 2019 amendments, and I mean, certainly not in the 2020 ordinance also. So why the legislature has been holding back from introducing, emergency arbitrations, I guess it's a question we can debate, but we won't have a real answer to. But the fact is that globally, this is a very well recognized principle. I mean, jurisdictions across the world like Hong Kong, Singapore, New Zealand, they all have, amended their acts to include emergency arbitrations. And even more telling is the fact that institutional rules, both, like ICC, CIAC, LCIA internationally, but even our Indian institutions, which are becoming bigger by the day, MCIA, all of that, they all provide for emergency arbitration. So I would say it was a concept that was sort of accepted tacitly, but obviously by virtue of the fact that the act was completely silent, it was always up for debate. So in that sense, this judgment really does close the loophole on one aspect of it. Does it mean that we've seen the end of all questions relating to emergency arbitration? Certainly not. I mean, if anything, this is going to open a large number of questions which are still going to be determined. So I guess good for the lawyers, and parties just have to be a little more patient.
Thanks, Shruti. That really puts everything into picture. And I think before we really go on any further on the whole broad aspect of emergency arbitration, Surya, would you take us down the judgment and break down the issues that came up in the judgment? Where was the dispute really? What were the issues framed? And please give us the lay of the land on that.
Sure. So, to understand the issues which arose for consideration in this judgment, we must look briefly at the conspectus of the facts involved. So, as complex as it seems, the dispute is fairly simple. Amazon decided to invest upwards of 1,400 crores in Future Coupons Private Limited, on the premise that FRL would not divest its retail assets into any third entity, and there were certain special rights which FCPL had, uh, which kind of protected any dealing of FRL with its retail assets with any third entities. So it was a protectionist shareholders agreement, so to say. There were two shareholders agreement and one share subscription agreement, and the idea was that Amazon's investment in FCPL would flow down to FRL on the basis of these special covenants. Now, FRL was facing a lot of liquidity issues, and the COVID situation only exacerbated its issues. It was approached by the Reliance Retail Limited Group, owned by the Dhirubhai Ambani, Mukesh Dhirubhai Ambani Group, and it entered into an arrangement whereby FRL's retail assets were to be transferred and divested to Reliance Retail. This was certainly a prohibited act under the two shareholder agreements because Amazon's express consent was not taken or obtained. This led to Amazon filing an emergency arbitration proceeding or initiating the arbitration under the SIAC rules. And Mr. V.K. Raja, a senior counsel in Singapore, is a legal doyen in Singapore. He was appointed as the emergency arbitrator. On 25th of October 2020, the emergency arbitrator passed its award and injuncted Future Retail Limited from going ahead with the contemplated scheme. It also injuncted Future Retail Limited to make representations to statutory bodies in India and get the scheme of amalgamation approved from the NCLT. Now, interestingly, after these injunctions, Future Retail Limited and the Biani Group did not file an appeal under Section 37 of the Indian Arbitration Act, but chose to challenge it in a suit for tortious interference and filed an application for injunction under Order 39, Rule 1-2 of the CPC. Now, the learned this suit this application was disallowed and it led to an appeal, but that's a different set. Now, what we are concerned in this judgment is that Amazon filed an application under 17.2 of the Act seeking to enforce the emergency arbitrator's award. Now, two questions. The learned single judge of the Delhi High Court accepted this contention and enforced the award under 17.2. This was appealed by FRL. In appeal, the single judge's order was stayed, eventually went up to the Supreme Court, and the Supreme Court, Justice Nariman said that I will decide the issue once and for all. He made two issues. The first issue being whether the award of the emergency arbitrator passed under the SIAC rules can be said to be a order of an arbitral tribunal under Section 17.1 of the Act. And second, whether such an enforcement order passed under 17.2 of the Act is amenable to any appeal. Now, appeal, one under the Indian Arbitration Act and second under the Code of Civil Procedure. So these were the two issues that arose for consideration.
Thank you, Surya, for putting out the issues. For us, taking that further to Kritika, the issues framed, why have they been important in the matter, and Um, did they require attention according to you? How do they solve the problem that everyone was facing?
Uh, I feel the issues were framed in a really minimalistic kind of a manner in this case. And what I feel is that although the issues were framed in a minimalistic manner, they have been answered in a very, interpretive and, kind of really good, digging deep into the layers of the legislation kind of thing. So, having said that, what I find most interesting about the issues while I was doing my own research and wondering, just being the devil's advocate, uh, what I find interesting was that another issue that they could have raised was the substance of the award itself and whether it was amenable to other general kind of interim awards passed in under Section 17. And there are some interesting things, and if they would have perhaps taken that issue, maybe it may have helped their case a little, because anything for which compensation is payable, or there are just so many other things that you could have said about it, and maybe if there would have been another third issue, it would have completed the wicket, for a better match.
So, Kritika, what are some of the best made arguments in the matter? And if you could elaborate on, some of these things that may have been missed a little more in detail.
Right. Ashima, if for people who have to read these kind of judgments every day, we tend to develop these really stupid quirks. And so one of my quirks is that I start reading people through the arguments that they are making, and also the judges. So this is just a disclaimer on the basis of what I have been reading all these years. And so I'm going to focus on a few of the observations that I have realized, and also try and make some knowledge addition while I do that. So let's begin with senior advocate, Mr. Gopal Subramaniam. His arguments, they were like a real serenade to Justice Nariman. So if you read Justice Nariman's judgments, especially the recent ones, PASL versus GPAR, you know that he loves party autonomy in arbitration, and that he's a very big advocate for that. And so, he ended up hitting just the right bars. He argued party autonomy. He pointed out mistakes, technical errors in the Delhi High Court judgment, which Justice Nariman is not very kind about. And he's very particular about his own judgments as well in that regard. And so, Mr. Gopal Subramaniam, his arguments were really targeted at the crowd. And I really appreciate that, because there are certain different types of arguments that you can make. And that is one of the best ones. You've read the code and you know what exactly you're doing. Having said that, I think arguments made by Mr. Harish Salve were like Switzerland. So he was like so neutral. His arguments would have been there before any court, before any judge, and they would have still made sense if you're representing a party. And so you have to, praise him for that. One very interesting argument that was made by Mr. Harish Salve, but has remained open-ended in this judgment, is what happens to third parties who are really not part of the arbitration proceedings but are affected by the enforcement proceedings. What about them? The court has, of course, refused to answer it in the present case, but that will be a very important aspect going forward, because, third-party funding in arbitration is picking up all over the world. It's landed in India. And will soon catch up, I hope. And so from that perspective as well, it's going to make a really important, contribution, but we need to wait for that. He said that the third party is not before me, so I'm not going to answer that. So all you third parties out there, I think we need to, resolve this issue. Lastly, this is more on a personal note. I want to salute Mr. Vikram Nankani. He actually distinguished the Kakade judgment from the Jet Airways judgment. And I want to thank him for making that argument. It shows two things. One, his own insight into whatever judicial, the happenings are happening around arbitration. And at the other side, I want to thank his juniors for, having that kind of a passion for law, for coming up with a distinguishing judgment and, not taking the control of approach, with the ongoing technological things that we are really suffering from. So I think those are some of my favorite ones from this judgment.
Thanks, Kritika. Thank you so much for bringing that to attention. And another question on the shareholders' disputes that I would like to ask you along with this is, how has the issue of urgent interim relief in shareholders' disputes been a sore thumb for practitioners in your experience?
Ashima, these people had an arbitration agreement. They had referred to the SIAC rules, which has, in a way, it's upgraded with all the new things that are happening in arbitration. You have all the new kinds of recourses, as if a waiver of appeal or an emergency arbitrator. But we don't always have that recourse in India, even for as simple as freezing of a bank account. Shareholder disputes are always turning into criminal matters for no reason whatsoever but to create pressure. And I think that is where we are lacking in India right now. We need to create a recourse for minority as well as majority shareholders in asserting their rights and also taking up their responsibilities. And it's something that we are presently lacking in. Having said that, the SIAC obviously provides really internationally accepted high-end services, and Indian companies are some of the biggest contributors to arbitrations at SIAC. And so I think one way also to cater to Indian disputes in India, apart from having the recourse of Singapore and other jurisdictions, is perhaps we need to look at having, now that we have opened the door, maybe we need to look at institutional arbitration centers providing the same kind of functions and rules, and allowing parties to get recourse to emergency arbitrators from that perspective. But shareholder disputes and respite for shareholders is an issue that is unresolved. Only having a few institutional service providers providing emergency arbitration is now, well, at least we have something in our arsenal now to help our clients. But it's just the tip of the iceberg, and there's just so much we need to do to really make ease of doing business happen in India. Which goes to show, and foreign shareholder invested 1,400 crores and had to go for an emergency arbitration at Singapore. So we need to buck up.
Thank you so much, Kritika, and so many great points there, and taking them all to Mr. Jain. Alok, what are your thoughts? And we've heard from the floor that what's the current position on law. Now, so many points from everybody. What are first your thoughts? Would you like to weigh in on them? And then what is the potential impact of this ruling? And what does this mean for the industries? You've also mentioned in your opening comments for construction contracts and other such contracts. Now, also looking at dispute resolution as a whole, how does this impact the model clauses that we're going to look at into, entering into our contracts? So many questions, but over to you.
Thanks so much. I think I'll probably do something what Kritika was talking about, emulate three of the idols in this matter, and that is Gopal Subramaniam sir, Mr. Nankani, who was in fact my boss at ELP for some time, and of course Harish Salve. So let me look at the way the law is settled in Mr. Salve's style. That is, to put it out in crisp points. First, that emergency arbitrator is in fact a creature of the contract and therefore deemed to be an arbitral tribunal within the meaning of Section 2D. So that is now settled. The second point is that emergency awards, where the seat is in India, is going to be akin to an interim order of an arbitral tribunal under Section 17(1). So that's the second takeaway. The third takeaway is basically that an interim order of an arbitral tribunal, as we all know, is capable of being appealed under Section 37. So if an emergency award is akin to an interim order of an arbitral tribunal, therefore an appeal is maintainable under Section 37. But no further appeal is maintainable thereafter except for an SLP. So that's the third takeaway. The fourth takeaway, which is the second issue that Suvigya was pointing to, is essentially that if the interim order is enforced, it is to be enforced like an order of the court. Therefore, the order, when it's being enforced under Section 17(2), you have to look at it in terms of the Arbitration and Conciliation Act and not the CPC. So no appeal will lie from an order enforcing the emergency award. So that is now the settled position of law. And as Kritika rightly pointed out, when it comes to certain other aspects such as impact on third parties, that question is pretty much open right now for debate. And as Shruti also rightly said, that there are, I mean, this is just, as you would say, the groundwork for emergency arbitrations in India. This is not the entire thesis that is yet to unfold. And how high courts will look at this is something that is going to play out over a period of time. Now, coming to your second question, which is the potential impact in terms of on the industry as a whole. As I said, this just does not affect shareholders' dispute. It affects a lot of other industries, construction industry, for example. In a current matter that we are doing, there is an issue where we need to stop the employer from deducting amounts on account of an erroneous interpretation of a statute. And it's a prima facie case. And today we are struggling because the emergency arbitrators mechanism is not available to us because why? It's an ad hoc arbitration. It's not an institutional arbitration. So the impact, I think, first needs to be looked at in terms of what are the types of arbitration in India. You have largely ad hoc and institutional. And since emergency arbitration are basically found in institutional rules, I think what this will do is it will propel a lot of people to move away from ad hoc towards institutional arbitration. So that is one of the biggest impacts that I see. In terms of drafting of clauses, I think what's important to understand is, again, looking at whether ad hoc or institutional, most parties would prefer to just adopt the model institutional arbitration clause. You would rather not tinker with it. You would just straight away adopt it. The reason why you would do that is all of them provide that once you adopt their rules, emergency arbitration becomes part and parcel of the agreement. You have a choice to opt out. It's not an opt-in choice. So that's very important. But please remember, I mean, while we are all dispute resolution lawyers, at the end of the day, the shareholder agreement is entered into by negotiating lawyers. And for them, it's very important to understand whether to opt out of the emergency arbitration also. So one of the questions which normally a lawyer wouldn't ask his client at the time when the agreement is being negotiated is, are you likely to breach this agreement? Because if he is, you would want to opt out of the emergency arbitration clause. So you would say, yes, I'll adopt the CAC rules or the ICC rules, but I do not want emergency arbitration. So you have to look at the flip side as well, because at the end of the day, you're advising both sides of the coin. It's not just one person you're advising. So that is the second thing that I would see. If I look at it from a perspective of, and this is something we've been talking about for the last almost 6 years, preferred seat India, for arbitration. Yes, it has improved. And this is a decision which is going to further that cause. Mainly because, as I said earlier, you don't need to approach Section 9 court. You can go before an emergency arbitral tribunal, and you can actually get the efficacious relief that you wanted. So it will boost it to that extent. Party autonomy, again, a hallmark which is recognized. Minimal court interference, again, a hallmark which is recognized. All very good for arbitration law in India and the development thereof. But still, I think there are a lot of massive problems in arbitration in India, which we must recognize and we must do away with. It doesn't take away the fact we don't have key infrastructure yet. It doesn't take away the fact we don't have an internationally acclaimed arbitral tribunal pool, from where we can select our arbitrators. It's good now you have Justice Nariman joining that pool. It's going to be something which is fabulous, but it's still a problem. And we don't have yet a specialized arbitration bar. And that is lacking. Why? Because as we all the panelists would agree with me on this particular point, we've come across a lot of opponents in our years of experience, and they are generally civil court lawyers practicing arbitration. They bring in all those concepts into arbitrations, and therefore you require a specialized bar, and we are still far away from that. So I think that is one major issue that I still see. But yes, overall, the decision is something which will further arbitration in India. One last thing before I wrap up my monologue is the fact that a lot of foreign lawyers have in fact been reaching out to Indian lawyers in the last week or so. And one myth that is circulating about this decision is that you can enforce an emergency award, which is not seated in India, also now in India. And that has to be dispelled thoroughly. Sorry, this decision restricts itself to emergency awards in India. If you have an emergency arbitration which is seated outside India, this decision will not apply. So the decisions which hold a field for such emergency arbitral awards, which are seated outside India, continue to be, as what Shruti rightly pointed out right at the start, raffles, as well as HSBC versus Avital. So it's not changed the scenario when it comes to emergency arbitral awards seated outside.
Thank you so much, Alok. There's so much to chew on, and you've made such great points and given us such clarity on all those points. I would now like to go over to Suvirtya and ask him on like Alok just mentioned. This is for India seated arbitrations. You may borrow the institutional rules. Now, where does this leave us in terms of where we are going? What's the way forward? It's one of the things that need more attention. That what happens to the foreign seated arbitrations and the use of emergency arbitrators, and what are the kind of if you could make a comparative analysis of the kind of institutes there are and what are the rules that they have, it would be great.
So, as Alok rightly pointed out, there's some clarity that needs to be there, and one myth needs to be dispelled that this judgment is not applicable to foreign-seated arbitrations. Now, how to enforce foreign-seated emergency arbitrable awards still remains an arguable proposition in India, relying on several judicial precedents, and we will not get certainty and unequivocal response until unless legislature really responds by way of an amendment. Now, there have been several recommendations made in this regard, and we are only left to wonder as to why the legislature is not doing it. Interestingly, many domestic Indian institutional arbitrations such as MCIA, DIAC, and several in Nani Palkiwala Center have provisions for emergency arbitrations. But because of this legislative loophole on the domestic side also, a question remains as to why a party in India would choose or adhere to these rules and not just approach a Section 9 court, because that's anyway an easier remedy. And there is also a sea of difference between what an emergency arbitration entails and what a Section 9 proceeding looks like. An emergency arbitration is always almost akin to a mini trial, and you don't want to subject yourself to such rigors. Now another question which arises is, if a party choosing SIAC rules is subject to a emergency arbitral award, can they really file an appeal under Section 37 of the Act? Because SIAC rules and other institutional rules also make a very clear distinction that emergency awards are not appealable or reviewable under their domestic or municipal laws. Now, whether 37 is a non-derogable provision of the Indian Arbitration Act or not, that remains to be answered after this judgment. That clarity is not there. Now, if I talk about a comparative analysis, Certainly, Justice Nariman has made reference to a lot of jurisdictions, both model law and non-model law, which have specific statutory provisions for enforcement of emergency awards. Even the English law, English Arbitration Act, which is a non-model jurisdiction, has it. Hong Kong did it in 2013, Singapore did it in 2012. So of course, a leaf out of the book of these legislations has been taken by Justice Nariman, but I have a I have a reservation where because what preceded the Amazon judgment was a very important judgment delivered by Justice Nariman in M. Hakim and NHAI. There he took a very sacrosanct, or so to say, a very circumspect view of not crossing the Lakshman Rekha and acting within the confines of the legislature. But here he has taken a very creative interpretation and let go. He has said that ironing out of creases in a statute is permissible, but I believe that it is a step, or rather two steps further than ironing out the creases. So these seem to me like the probable issues that may arise after the judgment. Of course, it has brought India's arbitration regime to a great extent at par with the international best practices, but it's a long road ahead because Indian lawyers are very creative and they'll find many loopholes after this judgment as well.
Thanks, Suvikya. Thank you for making that comment. And Shruti, would you like to weigh in on this? Arbitration Act is generally considered a self-contained code on matters pertaining to arbitration, which is like Suvikya said, considered or has been mentioned as exhaustive in nature, so to say. Now, with these judgments, we are adding layers to our legislation. What are your views? And in terms of the loopholes, what needs to be still plugged? We've heard some of those things from our other panelists, but what are your views?
Thanks, Ashima. I mean, to start with, I certainly agree with all my panelists. This is certainly a creative liberty that Justice Nariman has taken. I fully agree, and frankly, it also leads to some practical issues. Like Alok said, foreign seated arbitrations. I feel like this judgment could have clarified the point. The entire purpose of the Arbitration Act is to better the ease of doing business in India. So this limited judgment is great, but like Subhakya said, frankly, we there's barely any law on emergency arbitration seated in India because parties don't need to do that. They can just go for a Section 9 and then they don't have to go through the whole, rigmarole. And so we see them going for Section 9. So certainly, will this judgment change that? Will parties be more inclined to go for emergency awards? Yes. I mean, and in terms of loopholes, the interesting thing in the context of this judgment is really in the context of a particular set of rules. It really takes into account the SEAC rules. It interprets the provisions in the rules. Now, the SEAC rules also provide that your emergency award can be modified by the subsequent tribunal which is brought into place. So essentially, let's assume a situation where I have an emergency award in my favor. I've got it enforced in the courts, and maybe sometime later the main tribunal which is constituted changes that award. So in practical terms, in India, I'm here with an enforcing order, which means one of the parties is going to have to go back to court to have that order changed or modified to a certain extent. So while on one hand, party autonomy is great, on the other hand, if we come back to the point of wanting to stay as far away from judicial procedure as we can, but maybe this is something which is actually going to lead us not to, remove the burden in such great terms. I mean, certainly enforceability of arbitrary emergency awards, great step, but I don't believe that it's really going to decongest or bring down the burden, in the courts in any sense. I think another loophole, sort of just from the judgment, and this really simply because we are also agreeable, so I'm just going to put in a thought to see if we can disagree on something with the panel. There was a sense of whether this judgment is really blurring the lines between what is an interim award and what is an interim order. So an interim award is something which is actually appealable under 34, and the Supreme Court had held this in 2018. The name of the judgment, I think it was IFCO, I'm not sure. 2018, the Supreme Court said that an interim award is enforceable, is challengeable under 34. So the judgment, I feel, at some places does blur this distinction between whether this is an interim award or whether it is an interim order in that sense. But coming to the appealability aspect of, an order enforcing an emergency award under 37, that frankly, I fully agree with the judgment in that sense. Not that anyone's asking my opinion, but still, in the sense that, and the judgment makes a good point that when you introduced amendments to the act, you introduced 17 to equate the interim order of the tribunal to be as that of an order of a court. You didn't choose to make any amendments in 37, and you restricted 37 appeal to be appeal against an order granting or refusing to grant interim relief. So in that sense, going back to Kandla, which was a judgment we had actually appeared in that sense, they have kept the sanctity of, the Arbitration Act being a complete code in itself. Because the moment you get into, aspects of CPC, then you're basically undoing everything the Act is, has set out to do, which is to limit you to a certain procedure, limit your judicial interference to a certain way. So, I mean, I fully agree with the judgment and all my panelists on that aspect. I guess what remains to be seen, and I have a sense, depending, I mean, this is just my, some future reading, but I feel like this may be a situation where the legislation now comes in with a specific amendment to either agree or disagree with this. One of the reasons I feel they haven't done it so far is because it isn't as simple as Justice Nariman ironing out some creases or reading some provisions. Including emergency awards in the Act will require us to look at several other provisions of the Act to see how they will be impacted by it. So either we have a situation where the legislation comes out and brings out all the amendments, or they actually come out with an amendment to say, no, sorry, no emergency awards, then you're kind of stuck. So I guess that this is something that only time will tell, but hopefully we'll have better clarity. I mean, certainly there's going to be another judgment like this to actually determine on the concept of foreign seated emergency awards. That will be very interesting to see.
Thank you, Shruti. Yeah, thank you, Shruti, for sharing your thoughts. And we did ask your opinion on the ruling, so thank you for sharing. And Kritika, over to you. And taking, from what Shruti has mentioned, would you agree that it has the line between an interim order and an award? And also, like has been discussed now over and over, that law commission's report and suggestions were not taken into consideration while putting in provision for an emergency arbitration. What are your thoughts, and how does the law really need to shape up to make, again, to come up on the rank ease of doing business index, for that matter?
That's a wonderful question, Ashima. Thank you so much for that. As I said, this entire judgment, as I kept on reading it, I felt like I was, looking at a Van Gogh painting. So a lot of lines have definitely got blurred. It is, so long as we are not challenging it, it will definitely lead to promotion of institutional arbitration in India. And I personally am a very big proponent of institutionalized ADR. So that's a win for me. And apart from that, what I really feel, and the point that you brought up about the Law Commission, I also noticed something very interesting. Now, the judgment says that just because a Law Commission report recommended something and it was not implemented, doesn't mean that the Supreme Court can't take an interpretation of a statute that is possible. And then they've referred to another judgment that said this, that's Abitel Post Studios versus SSBC, which interestingly was also by Justice Nariman. And again, they've also referred to the high-level committee report by Justice Sri Krishna. I also, in a way, so I try and work on both ways. So I also work a lot in policy. And we've been really trying to get these kind of things into ADR legislations. And we are really hoping that we're going to cope up as soon as possible. One thing that has happened is that in a way it has recommended or diluted the value of these kind of reports, which means that, the Supreme Court decisions in a way trump these reports. But at the same time, it has also created a leeway that where the legislature is not able to take quicker action and are not able to implement it, perhaps there is room for judicial intervention in implementing these kind of things. Having said that, and based on a study of we've been looking at all the jurisdictions that Indians and even international companies working out of India favor when it comes to dispute resolution. They'd rather go to New York or London or Singapore, and that is because those legislations are really on trend, right? And you will see a ripple effect every time one of these jurisdictions changes any feature of their legislation. Every other jurisdiction implements the change as quickly as possible. The most important one being waiver of the right to appeal, which is there in the SIAC rules. It's what makes London famous for arbitration, and it's something that I don't know, even if we bring into India, we'll definitely go through a round of litigation saying that it's a right that you cannot forego and appeal to honi hi chahiye type. So, and so I think it's time that we come up with a structure in India where international disputes have a place with all these customized features that are made available to them in London or Singapore or New York, ease of enforceability being one of them. Appeal, there is possibility of an appeal in an arbitration. So for appeal against one arbitral tribunal in front of another arbitral tribunal in London, there is just so many things that we can do with the legislation. I'm not sure whether it can apply pan-India, but we at least perhaps need a safe harbor. Maybe we can work out a Singapore inside India or something like that, where international disputes get a place to get resolved that way, So I'm just being, wishful and Van Gogh-y, considering, I read the judgment so much. But that's my viewpoint.
Thank you so much, Kritika. That leaves us with so much to ponder over and, some great points to stay ahead of the curve. But Alok, what are your views, and are we even, matching the curve right now, comparatively, compared to other jurisdictions? Your thoughts?
Honestly, let's be practical about this. It's great to be feel good. That feel good factor is always important. It boosts your confidence. It's necessary, but we're way far from other jurisdictions when it compares to emergency arbitral awards. Also, I think Kritika pointed out something very interesting, and it's good that this discussion is going along these lines. Is what is the legislature looking at now in the future? And Shruti is right. This can go completely haywire because the legislature can come out with something which is exceedingly complex and can only end up in further litigation. I think possibly one of the best things that the legislature can do right now is take a leaf out of the UNCITRAL model law and just replicate, first of all, Article 17I, if I'm not wrong, of the UNCITRAL model law, recognizing even interim orders made by foreign tribunals. And that would be the safest way to enforce an emergency award in India. I think that for a arbitration seated outside India. But yes, I think the legislature is going to have a tough time looking at this ahead. I am not sure they're going to react very quickly, as Shruti rightly said. They need to think about this. They need to look at all of the aspects that play into what would be required, because it's not just one provision. We are talking about 17 or 37. We're looking at the interplay with various provisions. And on the aspect of award and order, I think it's, first of all, the major confusion arises from the fact that while it's called an emergency award, it's in essence an order. And but it is theoretically possible to actually have an emergency award per se. But I don't, in my personal experience, I've never come across one. Interim awards, yes, we have come across. Partial awards, we have come across, but not emergency awards in the sense that it is final on the issues that it decides. So that is a controversy which I don't see arising, but if it does arise, it'll be an interesting controversy to watch.
Thanks, Arun. Thank you so much. I think that makes Suvigya to answer the loaded question here. Suvigya, what is your opinion on what can of worms it leaves us with, and what is the way forward?
Well, I don't think it will open up a can of worms. I think the main objective behind the judgment was to give a push to institutional arbitration in India, because half the problems and half the malaise in Indian arbitration is because of domestic ad hoc arbitrations. Be it overburdening or clogging of the judicial system, or kind of bypassing the Section 5 mandate of minimum judicial intervention. This has largely occurred on account of ad hoc arbitrations. And as and when India starts moving towards that sort of system, and major part of arbitrations go to the institutional setup, we'll definitely see a realization of the ultimate aim of India, you know, at least aspiring in a true sense to become a international arbitration hub. As regards to foreign seated arbitrations, I think that journey will depend on various fact scenarios, and courts would take a view here and there. I don't see the legislature really adopting the views of the Law Commission report or the High Level Committee report and making foreign seated arbitrations per se enforceable in India. This is largely based on a hunch more than any sound logic. But I think I can certainly go wild creatively. This judgment at least allows me the liberty to really take erratic interpretations as well to support an argument. But yeah, the blurring of the lines, when it comes to blurring of lines between an interim award, and an order, the judgment surprisingly uses it interchangeably. There has not been an effort to even distinguish or kind of clarify in one paragraph as to how these concepts are different, and these concepts are not alien to Indian jurisprudence. So it would have been extremely wise if that reference was made in the judgment. But I believe future judgments would definitely take a corrective approach and clarify the position.
I mean, if
Thank
I
you
may
so
just
much, Suvigya.
sorry, if
Yeah.
I may just add to what Alok was with what Alok, Suvagya, and Kritika were saying. I mean, certainly in terms of what the legislature will do. I mean, I would have really thought that normally I would say that, okay, you know what, they're going to come by with an amendment to fix this whole issue once and for all. But what happened in the with the introduction of Section 87 in the 2019 amendment was essentially the legislature bringing about an amendment contrary to a position already settled by the Supreme Court, and then the Supreme Court and HCC having to fix that again. So really, there's no saying, I feel, what will happen. And to the point about this blurring of the award and order, some Enthu Cutlet lawyer is going to come along, take this judgment, and it's going to create havoc. So I fully agree. This is really just opening a Pandora's box. But yeah, I mean, I hope what Kritika says is right, and we can have, like a safe harbor in that sense in India. That would be amazing. I mean, simply because people don't want to choose their seats as India. And the fact that now two Indian parties also can go outside is like, now what is left, really?
Thank you so much, Shruti. I think that has been a very rich and enriching conversation. Thank you so much, panelists, for bringing so many aspects to fore. And with that, we'll wrap our conversation here. Thank you so much, all the attendees, for joining us. If you have any questions, please do leave them in the comment section. And we'll come back to you, on social media and with our release of the transcript of the webinar. So we quickly have one question, and I think we have some time, so we'll take that up. This is from Tushar Trivedi. While many of the complexities entailing this ruling have been elaborately explained or pointed out, my question is fairly simple. On what basis did FRL flout the clear-cut prohibition of non-disposal of its retail assets in favor of Reliance Group and hoped it would not be barred? Now, anyone would like to take that, or I could go around and ask each one of you to sort of give us your 2 cents on this.
I'm
Alok,
I'm
starting
switching
with
off
you.
my
Yeah.
video and my mic for this because it's a loaded question.
I
No
mean,
problem. Yeah, Shruti, you go ahead and then I'll add on.
sure. I mean, not making any comments as to the facts of the case. And my personal view, frankly, is that the actually it's fairly simple why anyone would not follow the emergency award is because in their arguments you will understand that they don't recognize an emergency arbitrator to be a judicial entity at all. So the argument really was that, look, I don't have to follow this, or I can go against what this says because this is not a judicial order. So that is really the thrust of what basis they took in law to maybe not follow the award. As far as the facts is concerned, I'm not in a position to comment really, but I'll leave that to someone.
Thanks, Shruti. Kritika, over to you.
Right. So I'm in this weird position where I'm also a transactional lawyer and also do dispute resolution. So I will sort of look at the facts because I found, Tushar, they just resorted to one of our most, transactional loopholes. They were in a way trying to transfer the assets to an entity that would effectually then further transfer it and amalgamate it with the Dhirubhai Ambani entities. So contractually, if you say that law it's legal but not logical, they did not, flout technically, but that will of course be decided by the arbitral tribunal and the, in the final award. But these things happen that way, and so in a way. They think it's possible to do that because the schedule in the agreement provided for certain entities which did not directly provide for the entity that they were transferring to or amalgamating with or merging with. And having said that, one another thing that we also have to look at it is from the entire competition angle that this entire story has. This is really a chessboard game. And if you look at it, there are only two key players in the retail market, one being Reliance, the other one mainly being Future Group. And then the next other retail player in India who is not, brick and mortar is Amazon. And so look at it as a chess game. I'll give you that hint. And apart from that, there are also a lot of still, pending cases right now in Delhi High Court. There is also this news item that says that another SLP has been filed, but I couldn't get a lot of information on it. So this is not the end, it's just the beginning. And so I'm sure they had their commercial considerations when they were taking that call. And what would have been also interesting to see is, had this gone to mediation, could they have just come up with an out-of-box solution for it? But presently, you will never know. So.
Thanks, Kritika. I think, Savitya, would you also like to, add to that and take, address this question?
Very, very simple answer. It was definitely premised on at least two eminent lawyers' opinions, or if not one.
which is why I was completely avoiding the question. But an interesting point has been made over here in terms of what Kritika was saying, a chessboard move. And you are likely to see an impact of this in the near future. Obviously, there are certain facts which are known to very limited people in the entire circle. But while this decision is great from the perspective of, looking at arbitration as a whole, the decision has also a lot of implications on the deal per se. So what is actually going to happen, you cannot predict whether it's going to be in favor of Amazon or it's going to be in favor of FRL. So it is, in fact, a strategic chessboard move, which Kritika rightly pointed out.
Thank you, Alok. And thank you so much, panelists, for sharing in your views today with us. And I think we don't have any other questions coming in. So thank you so much. We'll wrap this conversation here. And once again, thank you for sharing your wonderful views with us and sharing so many tips on lawyering. I think where to opt in, where to opt out, some great tips there. So thank you so much once again for joining us, and a good day and good weekend to you.
Pleasure.
Thank you.
Thank you.
Thank you so much.
Lovely being with everyone.
Bye.
Bye.